Hi there, and welcome to the Law Show. I'm Paul du Plessis. I'm an attorney of 30 years. I've been doing personal injury law for that period of time, and I've been honored to work with my friend, John Mullins, who's a senior advocate at the Petroleum bar. John, perhaps you'd like to just give us an idea of your experience.
How many years, Paul? I'm not even sure, probably 2 centuries. But I was an attorney first for 10 years. I've been an advocate since 1981, a senior counsel since, I think, 2002. And over the years, my practice has developed such that I do primarily insurance work and professional negligence work. And of course, that all involves damages, which is, I think, what we're talking about today.
Yeah, thanks for segueing into that. So there have been recent developments in the law of damages. Firstly, the one we're going to be discussing right now, which is the public healthcare defense. And I need to obviously set the scene. So in the law of damages, the rule is that you must claim in one action all your damages that arise from the incident that you're claiming. You must claim present and future damages, and you must be compensated in a lump sum.
Can I just jump in quickly? That's called the once and for all rule, which I think says it all. It says that if you're going to, it says this: you can't sue until you've suffered some damage. When you think you might suffer damage, when you even think you're going to suffer damage, but you haven't yet suffered any damage, you can't sue yet because you haven't actually suffered yet, and maybe things will change. The courts shouldn't be bothered with people who say, I'm sure I'm going to suffer. They must suffer first. That's the first component of the rule. But the second component is, as soon as you've suffered at least some damage, prescription begins to run because you have now, your cause of action has arisen, all the components are there, and you've suffered damage, and you must claim for all of your damage, present and prospective.
So what you'll have picked up now is that this show is not a wait for your turn to talk. We'll interrupt each other every now and then, and that's just the way it flows. So the law developed recently, over the last 20 years, medical malpractice suits have become more and more prevalent. And as a result, provincial health departments have come under more and more attack, more and more pressure, and it's a hand-in-glove sort of situation. The standard of care isn't as good as it should be, and as a result, you have many kids and many people that have suffered harm. And in order to try and lessen the burden, the financial burden of these judgments, the provincial health departments came up with what has become known as the PHD, the public healthcare defense. And the basis for the public healthcare defense is basically a plea of, instead of me paying you a lump sum, now you can already hear from that, instead of me paying you a lump sum, that there's an interference with the once and for all rule. Instead of a lump sum, I want to give you your future medical treatment in my hospital. This is now the MEC for Health.
And Paul, if I can just interrupt there again, I think we all, when we talk about this, have in mind the biggest medical negligence claims, which are cerebral palsy. Those are always going to be your biggest. Obviously, there can be bigger claims, and if an adult is paralyzed by medical negligence, that would probably be a bigger claim because that adult already has established an earning capacity, etc. But that's few and far between. So if you look at the cases that the provincial departments face, it's CP, cerebral palsy, are the biggest claims. And within a cerebral palsy claim, the biggest component is always future medical expenditure. Future, we call it hospital, medical and related expenditure, all of the treatment, the care, etc. that the child is going to require. Sorry, I jumped in there.
The second option is where there are services that the state can't provide, then the onus would be on the plaintiff to find the service and then, in a sense, bill the department, and the department would have to pay. And there was also the proposition that damages be paid in installments, again interfering with the once and for all rule. So in order to enable the PhDs to succeed, the defendants were pleading that the common law must be developed. In other words, that the once and for all rule must be changed to accommodate this kind of compensation. In the Eastern Cape, I think it was in 2003, John, in the Eastern Cape, there was a earth-shattering decision in which, in fact, it wasn't, the first one wasn't in the Eastern Cape, the first one was in Gauteng a number of years ago. And the two cases are on a similar footing, where the defendant was ordered to provide certain services, and it was very clearly set out and structured as to how the services would be provided. And in both instances, the defendants promised to provide the care in a structured sort of, we'll set extra special care aside for you so that you do receive care of the correct standard.
And so that you don't have to stand in the queues, you don't have to arrive and find out that the doctor is ill, etc. You'll get special provincial care.
So in effect, those two judgments changed the common law. The distinction between the Gauteng judgment and the Eastern Cape judgment was that in the Eastern Cape judgment, the standard of care required was simply a reasonable standard, whereas the standard of care required in the Gauteng judgment, the MSM judgment, was that outlined in the Ngubane judgment, which we'll get to later because it has some bearing on the PhD defense. So on appeal, well, let me first paint the picture. So TN was a classic cerebral palsy case.
And sorry, Paul, TN is the Eastern Cape decision you're talking about?
Yes.
Yeah.
Much evidence was led about what sort of services could be provided, and a sort of proposition was made as to how they would provide these services and in which hospital the services would be available. And the judge decided to reform the common law and order that services be rendered, and structured how things like physiotherapy, occupational therapy, and those sorts of things would be dealt with by the defendant. So he effectively didn't award a lump sum, and said services would be provided ad infinitum until the child passed away. The judgment obviously didn't find favor with personal injury lawyers and the defendant itself, and an appeal was lodged. And I must just give a shout out to the South African Medical Malpractice Lawyers Association, who entered the fray as an amicus, and I think added immensely to the substance of painting the picture for the court as to the applicable law and what the real test is before you can change the common law. So,
Paul, if I can just,
please.
Just jump in there. I think two things. The one is amicus means friend of the court. It's Latin for friend of the court. So in litigation, in important litigation, a party can join the litigation on the basis, I want to be a friend of the court. I want to give the court a different perspective in order to assist the court in arriving at the right decision. So that's the amicus side of things. And then, and I'm sure you were going to get to that, but let me just raise it now. Behind this, the PhD is a dynamic. The dynamic is this. On the one hand, you have injured people who insist on proper compensation, and who, in the nature of things, don't want to have to go back to the very institutions that harmed them in the first place. That's just human nature. If a doctor harms you, he's probably the last person you would want to go back to repair things, probably. But on the other hand, you have these provincial authorities, and at the end of the day, they're not profit-making institutions. They are our provincial institutions. They spend our money, and they're saying that having to pay these, at the end of the day, enormous amounts of money and damages affects their budgets and therefore their ability to provide the service. And so they are looking for a solution that saves them having to pay those amounts of money. But then the plaintiffs again say, well, hang on, ordinary people who cause harm aren't able to say, hang on, it doesn't suit my budget to have to pay you. So those are the dynamics behind it. Sorry, Paul.
No need to apologize. In fact, just jump in when you feel you must. Finally, the appellate division got the opportunity to, I suppose, really consider what changing the law of damages was all about. And the first case, its point of reference, the first case that it went to was a constitutional court decision of Mighty Solutions. And if you want court case references, these will be provided if on request.
Oh, okay. All right. But I was going to jump in there. I think you've got to tell them about what case it was.
But I don't know.
But that the Supreme Court of Appeal decided. You do know. In the TN case, finally the Supreme Court.
I'm going to get there.
All right. Okay.
Okay. So the quarter quo. No, I did actually, John. In any event, just to repeat, the quarter quo had ordered that the defendant, the Eastern Cape Health Department, would provide the services. So in lieu of a lump sum, the services would be provided, and there were certain hospitals that were identified that would provide the services. So again, the common law was developed and the appeal was launched. So I'm going to get, or let me now discuss what the appeal court, the SCA, how they went about working out whether it was the right time and the appropriate case to develop the common law.
And that, for the reader who wants to know about it, was in the case of TN on behalf of BN versus the MEC for Health Eastern Cape and a whole lot of other people, including the South African Medical Malpractice Lawyers Association as amicus curiae. There were others. And its citation, just in case people need, is 2026 ZASCA 14, 11 February 2026. That was the date of delivery of the judgment, 11 February 2026. I was just helping you there, Paul.
So what we plan to do is, and it's something John's not familiar with, is we'll probably put the reference of the case that we're talking about on the screen for you as a graphic. In any event, so in the Mighty Solutions matter, the Constitutional Court said this is how you work out whether you should be changing the common law or not. First ask, what is the common law? And in this instance, it's the once and for all rule. Then you ask, what's the underlying reason for the common law? And the underlying reason, as set out in Custom Credit Corporation, the appellate division judgment, is that there must be finality in litigation. The reason for a lump sum is that you don't have to relitigate and relitigate and relitigate the case. So that's the underlying reason.
And
then,
can I just jump in there and just say that principle that there must be finality in litigation is a really important one, And it comes to us because at the end of the day, there's only one purpose of law, and that's worthwhile for all law students to remember, even though I'm not sure you can easily give it as an answer to an exam. There's only one purpose of law, and that is to regulate society. If you only had one person alive, that person wouldn't need the law because he or she would be the law. But as soon as you have more than one person, let alone the billions that we have, you need law to regulate the way we deal with one another, including in this instance, how we deal with one another when somebody negligently causes harm to another. And litigation has to serve that purpose, and it won't serve that purpose if it goes on forever. It will probably serve the interests of lawyers if it goes on forever, because it's a wonderful pension scheme if one case can go on forever. And there was a case in England, and I mention England because our law of procedure and of evidence comes from England. A case in England called, I think, the Amt Hill peerage case. If I'm not incorrect, it had to do with a wealthy family, an eldest son who would have been the heir, who disappeared on a trip to Australia, and then years later, somebody who didn't look like him, who didn't sound like him, but who was of the appropriate age, who pitched up at the front door and said, "I'm your long-lost heir." And that led to an immense amount of litigation because he obviously wasn't the heir. But the grieving mother, she seized on him and the hope that he was her long-lost son, etc. And that litigation went on for certainly for decades. And it ended with the House of Lords in England saying there must be an end to everything. So it's worthwhile just remembering, I know that was a bit long-winded, but it's worthwhile remembering law has to be practical and it has to be sensible. Litigation has to be practical and it has to be sensible. And there has to be a practical end to litigation. That's why the once and for all rule might not sound all that fair, because you can think of circumstances where it wouldn't be fair, but it's a practical solution to making litigation work. Sorry, Paul, I'll say sorry for the last time.
The last time. So we started off, what is the common law? What is the underlying reason? The next question, does the rule, that's the common law rule, offend the spirit and object of the Bill of Rights? Next question, how is it proposed that the common law should be developed? And then, crucially important, is it must be taken into account the wider consequences of developing the common law. And as a final caveat, the court in Mighty Solutions said the major engine for law reform, and it in the judgment, in the SCA judgment, in the TN matter, this gets repeated over and over again. The major engine for law reform should be the legislature, and particularly far-reaching changes.
And if I can interrupt again, those who've even heard of the Constitution probably know that's a factor of the separation of powers. So our Constitution provides for various powers. There is the legislature, which has its powers to make laws. There is the executive, which has its power to carry out the laws. And then there is the judiciary, which has its power to temper all of those law-making powers and those law-executing powers. And the judges of South Africa, who have immense power, they have to constantly bear in mind that there is a separation of powers, and they must be relatively circumspect in exercising their power, and they mustn't take over or tread on the power of the legislature and the power of the executive. So the principle there is mighty men. Is it mighty?
Mighty
men?
Solutions.
Mighty Solutions. So the principle there is, in terms of the separation of powers, judges, stick to your knitting. Don't make a massive change to the law. If a massive change is, in your view, needed, that's something the lawmakers must look at, not the judges. Judges' changes to the law, where required, should be incremental. And if the situation in front of you seems to require, to your mind as a judge, something massive, not incremental, well, that's a good indication that you're stepping onto the toes of the legislature in terms of the separation of powers.
I think as a starting point, the SCA said now is not the time, and we are not the body, the courts are not the body to change the common law. It should be the legislature. And I'm going to give you some excerpts from which were very informative to me. So, firstly, arising from the services remedy, this is from the judgment, arising from the services remedy, and that's we'll provide you services instead of giving you a lump sum. There will certainly be disputes that a court will have to resolve on each occasion that a service, treatment, medication, device, or equipment becomes unavailable for whatever reason and a dispute arises. In the undertaking to pay, undoubtedly there will be disputes. Open-ended remedies, such as what I've just described, undermine finality. So in those descriptions, you can just hear the court clearly, and we'll go back to Mighty Solutions. Does it offend the underlying reason for the law? And you can hear from those excerpts that it most certainly underlines the principle of finality. They say the rule is designed to prevent those issues from ever arising.
So that takes you back to that once and for all. What the court was saying, I think sensibly, was the PhD is all very well in concept, but just think of what you are condemning that claimant to. You're condemning the claimant probably to constant disputes, constant litigation, as the department says, well, we gave you the treatment, and the claimant says, but what you gave me wasn't good enough. The law would have allowed me to gain a lump sum and then go to the people I want to go to, and if I don't like those people, I go to somebody else. I would have had that freedom. But what the decision condemned me to is a constant relationship and constant disputes and litigation.
So often quoted as a starting point, as a basis for changing the rule, is the Constitutional Court judgment in the DZ case. Again, we'll put up the references. And it was a comment made not related specifically to the judgment, but we call it obiter, which is almost an aside, but which is instructive as to the thinking of the court. And there it was said that if you wanted to establish or succeed in a PhD, you would need to prove the following. The SCA said that comment and that obiter statement is not a basis for changing the rule, and it referred to the Constitutional Court judgment in DZ and said the major engine for law reform is the legislature. Another comment, over time the law in any area may change, but the process of change should be incremental, little bit by little bit. In a constitutional document, in a constitutional democracy, the legislature should assume the major responsibility for law reform. Again, I'm going back. I told you that it's a recurring theme in the Supreme Court of Appeal judgment. Allowing the PhD would not be an incremental development. Rather, it is a radical restructuring of the law of damages. So, laying the basis for it not being the right solution.
So you'll remember what I said. That's the thing. They said, such a big jump, that's not for judges to make. That's for the lawmakers to make. Judges must make incremental changes. If you see something that seems to require rectification in terms of the Constitution, you can make incremental changes as judges. But if it's a great leap forward, which might to others seem like a leap backward or a leap sideways, leave that for the legislature.
Another quote, the PhD, and the words of the court were not specifically the PhD. They were referring to the Eastern Cape Quarter Quo judgment. But the terms of the judgment were pretty much the implementation of the PhD, so one can read it as that. It offends the right to equality because it differentiates between the victims of medical malpractice in private care from those in public care. Those in private care will get private care and they will get a lump sum. Now suddenly, just because you happen to have been injured in a public hospital, now suddenly you're not entitled to a lump sum. You have to be subjected to public health care for the rest of your days. And when I say subjected, please, I respect the fact that there are some excellent doctors and excellent services rendered in public healthcare institutions. One is obviously speaking generally, and I think there must be a general acceptance that as a general rule, the quality in the private space is far superior to that in the public space. Then the SCA found that forcing a person to undergo healthcare in a specific place
and taking away the right of choice.
Taking away the right to choose offends the person's dignity. Then, going back to the mighty solutions rules for changing, the court said this: reforming the law of damages involves policy-laden decisions. It is not merely correcting an injustice, but reshaping health policy and public finance and impacts upon the rights to dignity and equality before the law. These are legislative questions, not judicial ones. Again, going back to the statement that this is not for the courts to decide. Very interestingly, the SCA referred, when talking about a legislative process, to the UK parliamentary process in terms of which they reformed their law, and the amount of consultation that could never ever take place in a court of law. Consultation that involved insurers, actuaries, law commission reports, medical cost projections, claimant groups, lawyers, massive consultation that would have to be undertaken by, in our country, the Law Reform Commission. And the process was started, I think, 2016, 2017, 2018, around there. And I think got overtaken by all these public health care defenses, and maybe the legislature said, well, hang on, maybe the courts will solve this problem for us. And clearly the courts have now said, sorry, it's for you to do. So a last reference to the DZ judgment, the inability of the court, this is now the words of the SCA referring to DZ not reforming the law, the inability of the court to recast the law of damages, and the reason why it should not do so were not before the Constitutional Court in DZ, and that's why it was never reformed. Moreover, the suggestion that the remedies be considered was obiter, and the court itself emphasized, and I'm going to say it again, that the major engine for law reform is the legislature. So, as an aside, another reason why the Eastern Cape Court figured that it should change the common law was because of contingency fees agreements, and that's where lawyers come in. Contingency fees agreements enable lawyers to work for nothing if the case is unsuccessful, but to charge a higher fee if successful. And it doesn't seem to make sense to me, and the SCA agreed that the fact that the attorney would take a portion of the compensation isn't a reason for not awarding a lump sum to a plaintiff, because the award remains the same. But in any event, the SCA did say that contingency fees promote access to justice and gives effect to Section 34 of the Constitution. So, in a sense, just maybe reminding everybody that instead of bashing the concept of contingency fees, that it's a big part of the engine of how the law works and how people get access to courts. So, John, is it the end of the PhD?
No, I don't think so. It's the start. It's the start of a PhD battle in the legislature. Well, to start with, of course, the state might well appeal to the Constitutional Court, which is the court above the Supreme Court of Appeal, and probably will, but that's a very powerful judgment. It's a powerfully reasoned judgment. It's a judgment that almost takes a step back and says, forget about the excitement. Let's look at basic principles. And whilst I think it's likely that they will appeal and therefore it will have to be decided in the Constitutional Court, I think one can predict that the Constitutional Court would uphold that reasoning because it is sound reasoning, and thereafter the fight it is, would go to the legislature. And that just takes you back to one of the points that were made there by the Supreme Court of Appeal, which is, I spoke of that dynamic. You've got the provinces saying, but this is the people's money we're administering. This is the people's money we're paying. By the same token, the PhD, by definition, only applies to those who do not have the money for private care and who therefore are compelled to accept provincial care and who are injured as a result of having to accept provincial care. So there is an inherent discrimination involved in that it's only they who would be subjected to the PhD if the legislature should decide to introduce it into statute. So one can see a long and worthwhile fight there. Having said all of which, if I can just say something on that, I think if you take a leap back, there is a problem. The problem is, firstly, rampant negligence in the provincial sector, and I don't believe that can be denied. The reason why there are so many of these claims, the reason why the provinces, in relation to the standard of their care, because that is so, why the provinces in relation to the standard of their care have these massive claims against them. Western Cape has the least. Eastern Cape, I must be careful before I say which, but certainly I think Eastern Cape has the most, and you can look at the standard of care in the provinces and you'll find the amount of claims they're facing is in relation to the standard of care. You can't deny the fact that at the root of it is rampant negligence. I'm always struck by the fact that in all of these cases that I do, and that Paul does, and that Paul and I do together for plaintiffs, never, and I mean never, not seldom, I mean never, do I come across an inquiry that the provincial department itself made into what went wrong. And I emphasize the word never. And if you're dealing with departments that don't have sufficient power of introspection to ask themselves what went wrong, well, then you're dealing with departments that don't have sufficient initiative to work out how to eradicate what went wrong. I might sound like I'm going on a polemic there, but to me that's important. But by the same token, it is a problem. I believe there is a solution to be found. There is some sort of a compromise to be found. I'm not sure what it is. I do believe it might have to do with some degree of limitation of claims against the provinces, which is in itself discriminatory. It might have to do with, for example, distinguishing between those provincial claimants who are illegally in South Africa, who are from abroad but legally in South Africa, and those who are South African citizens or permanent residents, and distinguishing in terms of the degree of compensation, etc. I think a solution is to be found, but I think I went on too long there.
John, the SCA actually made reference to the case of MSM, the Gauteng judgment, and expressly said that was also wrong.
Yeah.
Now we know we've dealt with Professor Alec van der Heever, who's referred to in glowing terms by the court in this judgment, because he unpacks and he compares the various provincial healthcare departments, obviously establishing the Western Cape as the standard bearer, albeit a below par standard bearer in relation to, I suppose, standard healthcare, private healthcare. And that brings me to the Ngubane case, which is also then an appellate division case. It was early 90s.
Can I interrupt again, Paul? I mean, you made the point earlier. We are criticizing the standard of provincial care. And we're saying, for example, that the provincial care in the Western Cape is markedly better in terms of the various markers that are used than that in the rest of the country. And of course, the question then arises, well, if they can do it, why can't you do it? That's a very valid question. It's a question that Professor van der Heever raises. But the point needs to be emphasized again and again that you made earlier, Paul. One knows that there are wonderful people, nurses and doctors and administrators in provincial care throughout the country who are doing their absolute best in difficult circumstances to ensure the best of treatment, so that those generalizations are not accusations against those individuals.
The Ngubane case is one which sets out that one has to mitigate one's damages. And the principle there was about, well, if you can get care for free that is equal to or better than that you would get in private healthcare, then it's reasonable of the court to expect of you to go and get that care and to not lump the defendant with the cost of private care of the same standard. Does that mean that there's a possibility that the Western Cape would succeed with the public healthcare defence if it were to prove that the standard of its healthcare is on par? And then you would have this, if I can bring back the uncertainties, the litigation, the further litigation, the lack of finality. For me, the two concepts clash. What's your take on that?
I agree with you, Paul. I can't see that the Western Cape would succeed in terms of that SCA decision, even though the standard of their care is perhaps markedly better than in other provincial sectors. And I think the reason is to be found in that decision. The Ngubane case that you referred to. Ngubane was, what was it, 1990, I think? It was a decision.
It was around that time.
What was then the appellate division, now the SCA. And Ngubane involved a person who had been injured in a railway incident, and the railways, then the South African railways, their argument was, well, you can mitigate your damages. And everybody who suffers damage is obliged to take reasonable steps to mitigate their damage. It's a basic principle of law. You can mitigate your damages by taking your treatment in future at provincial hospitals. And the appellate division said, the argument takes you only so far. Your problem is that the railway services cannot establish that the standard of care available at provincial authorities is the same or better, but let's just stick with the same, as in the private sector. And therefore, it's acting reasonably by taking your treatment in the private sector.
And another point in that judgment was you can't guarantee it's going to stay the same.
Yes, which is important. So I think, to me, there are two cases that stand out in that context. The one is a case in I think it was the early 1980s, might have been the 1970s, and I think it was called Williams versus Oosthuizen. It was a case in the Cape, and it was a case against the provincial administrator in the Cape. I can't even remember the nature of the injuries, but it was a white person, important to say, for reasons I'm going to explain. And the judge upheld a form of the PhD back in the 70s or 80s, where the defendant, the provincial administrator for the Cape, was saying, we'll give you the treatment that you need at Groote Schuur Hospital. And on the evidence, the judge said, that would be reasonable mitigation of your damages. What's your problem? That the standard of care available at Groote Schuur Hospital equates to the best in the world, I think he even said. Leaving aside whether that's entirely correct, remember it was the time of the heart surgery at Groote Schuur, Chris Barnard, etc. It's got to be seen in the context of its time, which brings me back to the fact that the claimant was white. Then only whites got treatment at Groote Schuur. That means that Groote Schuur didn't suffer from the population pressures that the provinces suffer today, because the population pressures were at the other hospitals, not the special white hospitals. So you can see how, in that context, it probably was reasonable for that judge to say, take your treatment at Groote Schuur. But even then, there would have been questions. Well, if you must take your treatment at Groote Schuur, does that mean you can't move to other centers of the country? Is that fair in terms of the once and for all rule? So the injuries there weren't all that severe. So the treatment in question wasn't lifelong, wasn't extensive. And that was the point that was made in Ngubane. It's one thing even to say, well, isn't it reasonable to restrict the claimant to provincial care? And it's one thing even to say, look at the standard of care. If we're talking about serious injuries and lifelong treatment or extensive treatment over years, the question is, well, will it stay that way once and for all? Is it fair to restrict the claimant to that treatment, because quite possibly in 5 years' time, the standard won't be good enough? What does he do then? Then he has to come back to court, and that offends against that sort of practical principle of law. There must be an end to litigation.
I think we've unpacked the SCA decision. I think we've unpacked the PhD. So I hope you guys found that informative and maybe helpful if you're running a PhD case, or if you're confronted by having to make a decision relating to it. So yeah, thanks for sharing your time with us, and we'll see you next time.